Yes.
I'm praying for listing this IA for modification of an order. Earlier,
Pray for listing, give it to the court master. Give all prayers to the court master.
May I please, Lord?
Yes,
I beg to mention two matters for listing to admission.
you just heard me.
For motion, item 13 for motion.
What is that? After some time.
Daily list, item 1.
May it please your lordship. Whether the petitioner is coming before your lordship for the fourth time, but I am seeking now default bill,
Default bill.
default bill.
Okay.
Your lordship, please to see page
And give
27.
notice, give it only next week.
Yeah.
Let them have a notice.
Yes,
When Mr. BC Das, then senior counsel, assisted by Mr. S.S. Rahman, counsel for the petitioner, and Mr. K.K. Parashar, the AVP for the state. Next paragraph. The learned senior counsel for the petitioner has submitted that this matter is this bail application is moved before this bench for the fourth time. Post op. It is submitted that this time the prayer for bail is made. The prayer for default bill has been made. Explanation notice to the learned. Issued the state to the learned APP. Post op. Objection, if any, be raised, will be made within a week from today. List on.
can it be after 2 weeks, my lord? Either on 14th or whatever.
15th, we are making
15th.
15.
My lord, in this case, Shasit already submitted. May I call for the scan copy of the record, my lord? Elsewhere.
Scan copy, I think will be available in the last.
Last, yes.
Just see our last order.
Page 77.
It's on January, yes.
77.
Page 77.
And
That
maybe
was, order was passed on 5th of January.
this record may be
Just a moment.
tagged, my lord. This will be.
The registry shall call for the scan copy of the orders passed by the learned special judge Karimganj in special and within bracket NDPS bracket close case number 155 of 2022 arising out of Karimganj PS case number 588 of 2022 from one 24 till date. We're just getting this scan copy of the order sheets after 1/1. Next one. Use this matter along with the records of bail application 4448 of 2023 within, comma, within bracket, disposed of by order dated 5/1/2024.
It is to be listed, my lord.
Oh, date is 15, stop, 15/5/2024.
15/5.
I'm seeking lordship indulgence, my lord, in item number 9, if my lord permits me to withdraw the same, my lord. This has become infractuous.
9.
Yes, my lord.
Okay, your name?
HK Sharma, my lord.
Revenue, Mr. Sorry. Upon instructions, Mr. H.K. Sharma, counsel for the petitioner,
Police. No,
seeks to withdraw this requisition as the matter has become infructuous.
yes, yes.
Ms. M. Burman, sorry, Mr. H. Sharma, done it. Additional senior government advocate, and Mr. A. Bhattacharya, standing counsel for the revenue department, are present. Matter stands dismissed as having been rendered infructuous.
Much obliged.
Time being item 1 or 13. Time being item 13.
It's a new case which has come, but AG has to be there. He is on the way, because ultimately a notice has to go in this case also. But let him come. My lord, only one, your lordship, please accommodate, because there are few cases, 2 cases which is listed yesterday, which your lordship has taken. Another case which is before your lordship is item number not 14, 12. Which your
Yes.
lordship will kindly accommodate me if I am on legs,
Okay.
my lord.
Okay.
If I am on legs, AG is also there in that case.
Okay, item 12 and item 13. Okay,
Along with 14.
you just inform the AG.
Please
May
try
come along
to-
with Mr. Das.
I just, AG has to be there. That's.
Daily list. Item 2 for admission.
Thank you.
Something is very amusing here. You are a Shibayat of the Satra,
My lord.
and you are wanting to occupy the land of the Satra.
My lord, we are.
No, that's okay. I am only on the word, use of word, Shibayat. The intention of a Shibayat is to take
It is
possession of
not
the.
our submission, my lord. It is reported by the honorable court.
Okay, yes, please proceed.
My lord, we are occupying our cultivation land since last long 70, 80 years, my lord. And also filed various representations, my lord. And we have asked before the authority to settle our cultivable land to our names, my lord. We are all the brothers, my lord. And regarding their affidavit,
ডিসপোজালৰ কাৰণে কৰিব নালাগে
disposal নকৰিলেও আপোনালোকে timely কৰিব
নাই
লাগিব।
কৈছিলো এতিয়া ডিসপোজালৰ কাৰণে বিচাৰি আৰু
Yes,
And my lord, the opposite party respondent number 4 had filed their reply, my lord, in this regard. And on the basis of that reply, after revision of the records, my lord, a honorable court has passed an order on 24/1/2024. There is an order dated 24/1/2024.
Yes,
To place the records on the basis of which the affidavit in question has been filed. My lord.
okay.
Because my lord, they have stated in their affidavit that land is reserved for DC court premises that was reserved, my lord, but actually they have settled land to other persons. We have filed documents by annexers, my lord, as a evidence, my lord, in our additional affidavit. Therefore, that record is necessary, my lord.
Okay. Yes, you have the records.
Malat Sitha is with us only, Lord. Sitha, that Sitha is with us.
It's relating to government act 4,
That-
my lord, where this reserve order is mentioned, my lord. That portion.
I'm not getting you. Please repeat again.
That my learned friend has stated regarding reservation, due to reservation order, that land was not allotted to them, my lord. That, but
No, that's not he's saying. He's saying that the acquisition was made and the land was reserved
yes,
for the purpose of deputy commissioner, but you,
Yes.
instead of that, you are giving it to others.
that
my-
record we do not have, my lord. This is the 3 and 4 where the reservation order has been mentioned. Initially, in our affidavit, we have taken a stand, my lord, that due to that reservation, this land was not allotted, my lord. So we
Where is
did
that
not annex
affidavit?
any.
Which page is that affidavit?
Para 5, my lord, page 2, para 5.
Which affidavit is which
five.
page?
Paragraph 5, my lord.
Which page? Whose affidavit?
The respondent
Page
number-
92, serial 92. my lord. Affidavit filed by respondent number 4.
It's found number 4. Yes.
All government plots, including acquired land of Sotros which were made Sarkari after acquisition, located within 2 miles from the subdivisional headquarter office, has been reserved in the name of subdivisional office Majuli. And earlier it was subdivisional office, now Majuli became a district. my lord.
Okay, so where is the record of this DAG number 3 and 4?
Yes,
Before that, may I make certain submission, my lord, on this system, my lord.
No, let him come. You complete your part.
Yes, thereafter I will make submission, then my lord lordship will finish the record.
Yes, ma'am. Then, my lord, we have filed an RTA application, my lord.
Now, what is the right?
RTA application on 8/3/2018.
Yes.
And my lord, on the basis of my RTA queries, my lord, they have filed the reply, my lord. Reply is at Annexure Q, page 58. It is in vernacular.
But you tell us two things. Number one, you claim yourself to be the inheritors for
Right,
the
right.
what you call freedom fighter.
My lord.
correct? Somewhere I have read that this freedom fighter was allotted land measuring 6 bigger odd.
my lord.
So after you have been allotted or your family has been allotted land under freedom fighters quota for 6 bigger odd land,
My lord.
under the Assam land policy, you're not entitled to any other allocation of land. That's one. Number two, if the land acquisition was made in the year 1984, if for any reason you are requiring any other land, you'll have to apply before the government, and the regulation would not be maintainable on that ground alone.
My lord, regarding that, my lord, the Sattarika has issued letters. My lord. That letter I have been annexed here.
Letters won't do. That's not the way land policy will operate.
My lord, it
You
was
will apply
given
if
to
the
our
government-
father, my lord.
Hmm?
Now I am 5 brothers with my families, my lord.
But definitely tomorrow you'll be 100.
My lord.
Can somebody stop?
My lord, it is regarding our cultivable land. My lord. And my lord,
Not have a right.
in the additional affidavit, we have enclosed all things, my lord. As to how government had settled land as their basti land, and on the other hand, foreign land, cultivation land. Lots of land had been settled. Therefore, my lord, your lordship may kindly peruse our RTA reply, my lord.
No, Mr.
What they
Patel.
have annexed.
You see, certain things don't fall in the line of thought. Number one, under the land policy, it is only those type of land which is a wasteland can be allotted. Foreign land is a cultivable land. If cultivation is not done, then we call it a wasteland, because otherwise it has no use except for cultivation of paddy.
My lord.
That's one part. The second part which I have put in my first question is that you have to show us your right that even if you are occupying that land, you have an indivisible right to hold it after you have been allotted 6 bigger odd land. You take a call, you either relinquish that 6 bigger land and make a claim for your land which you have been occupying, because you can't have benefit of two parallel allotments.
But in that land, my lord, we are cultivating for last 60, 80
Every
years.
good
my
thing
lord.
must come to an end.
But
Every
my
good
lord,
thing must come to an
government
end.
has settled land in other person's name who have basti land as well as foreign lands. We have filed all the documents, my lord, 11 documents in our additional
One
affidavit.
wrong does not make, will not allow the court to make it a precedent. If something is, the government has done wrong, we may, in the order of the court, we may deprecate it.
My lord, we have filed representation also before the deputy commissioner.
Representation doesn't work in land acquisition, land allotment.
As per the new land policies, my lord. May I read, my lord? It is regarding allotment and settlement of government land for ordinary cultivation in rural area.
Yes. This is land policy of
2019, my.
yes.
Point 1.3, it was reflected, my lord. The maximum limit of land for allotment for an individual is fixed at 3 bighas for agricultural and 1.5 bigha for homestead purpose.
Then we'll have to pass orders to in against you in your writ petition, saying that 6 bigger land should be appropriated in this manner.
And my lord, the maximum limit of land for allotment to an individual is fixed at 3 bighas for agriculture and half bigha for homestead purpose. We have 5 petitioners, my lord, along with our family members.
So in my home, if there are 5 people, all 5 will apply for land. You have 140 crore population in the country. So how much land would we require? Supposing this policy is applicable for the entire country, and imagine the land holding which is required. In the country, we won't even have that amount of land.
But the provision reflects that maximum allotment for individual at 3 bighas we can get, my lord, according to that policy. My lord.
I don't know. This 1.8 explanation. Family means
Settlement for ordinary cultivation in rural areas may be given on the basis of a family, and all settlement of land both in rural and town areas will be made conferring joint title of the husband and wife if the applicant is married.
okay. Yes.
And 1.11, my lord, regarding the sword area.
Is there a notified char area in
Madhuli sword area.
Sorry, I don't know. Yes.
It was right in para 1.11. If permanent sword area settlement of land shall be made with the deserving landless indigenous people as per land policy. For the purpose, cadastral survey in sword areas would be made on priority basis as a phased manner before such settlement in sword areas. My lord, we have stated our repetition that there is no any survey, my lord, regarding Majuli at Majuli, my lord. Even after declared as a district, my lord, there is no any land survey at all. And my lord, in many matters, government had taken up lands from the people and they are deprived from getting land compensation due to that lack of survey. And we have given land to establish a 100-bedded hospital, agricultural office, CRPF camp, etc. from the Dak number 3 and 4, which we are occupying along with others. There is record, my lord. Therefore, Honorable Court has asked for the record, my lord.
Okay.
So Lordship, may I kindly for a moment look at to annexure Q, my lord.
Annexure
Q, page 58.
58.
It is a reply of our RTI.
Yes.
May I read in the
The,
particular
the,
portion?
the land which you are presently holding, is the copy of Jamabandi or Chita anything enclosed?
My lord,
The land which you are presently holding,
my lord.
is there a copy of Chita or any land record available here in this record?
No, my lord.
It's not there. Where is your application for land settlement? Where is your representation for land settlement?
Representation, my lord, various representations. Last
Show me one.
representation is page 61.
60.
There are many representations
Please,
from
okay,
time to time.
show me one.
Page 61 annexure, it is in Bhadikula. We have enclosed translated copy. We prayed for spot verification and for settlement. By referring three letters, three earlier letters. And closing there.
Okay. 58, we have seen that.
'58, which is Bhanikula. They have stated that altogether duct number 3, there were total land 110 bigha, 4 kotha, 13 lessons. And up to 2017, they made Miadi 50 bighas, 1 kotha, 6 lessons of land. Remaining part are Sorkari land, government land. And regarding duct number 4, they replied 77 bigha, 3 kotha, 5 lessons land. And up to 2017, they make Miadi 8 bigha, 0 kotha, 5 lessons. And other part government land. If the land is reserved regarding duct number 3 and 4, then how they make Miadi? And at that time, our land was not making Miadi. It is their own reply. And we have stated that we have already give up our possession to establishment of hospital, CRPF camp, agriculture quarter, etc., etc.
Yes.
Therefore, record is necessary. Because in their own RTI reply, it is seen that all up to 2017, 56 bighas, 1 kotha, 6 lessons of land become Miadi. They have done Miadi, 2 others. And regarding duct number 4, 8 bigha lands become Miadi. If they stated without any record that land is reserved for in 2 kilometer radius, 2 miles radius.
Yes. Anything more?
My lord, therefore, I prayed for calling the records, my lord, how they became.
Record
They
says that
different
it's available.
land.
Whatever records of 3 and 4 are there is available. On merit, you have anything more to say?
We have going to prepare a written argument also, my lord.
No. If you want to take adjournment, take it at 10:15. After I start hearing, I spend my time. After
My
that,
lord, we have a written argument.
then give it to the court master. Yes.
Yes.
And my lord, we are submitting 3 citations regarding
What are the citations?
order passed before by this honorable court. Citation kita koi diya ase.
Just give the citation to the learned additional advocate general.
Judgment dated 10/6/2020 passed in WPC number 292 of 2020. Odun Kumar Singh and 10 others versus State of Assam. In the judgment, the Honorable Guwahati High Court directed to file application before the Deputy Commissioner Kamrup Metro by giving all opportunity to the petitioners for hearing and to produce relevant materials, documents, etc. by relying upon them and thereafter pass the reasonable order. That direction. And
This is
another
judgment
judgment
of-
dated,
Judgment of which date? This is judgment of which date?
my lord. Order dated 10/6/2020.
10/6/2020.
2020.
That's not implementable order right now because we have, the state of Assam has introduced the Vasundhara scheme. There cannot be an application to the deputy commissioner now, not by bypassing the portal. You can't permit that to happen.
And my lord, there are another 2 orders. Order dated 25/9/2023. It is in the year 2023. Maybe second phase of Vasundhara or thereafter. It is passed in WPC number 3929/2023. It is, there were 3,923 petitioners who are claiming to be landless persons who have been occupying the plots of Sarkari land in question, though their ancestors since the year 1954, and the petitioners have been cultivating the aforesaid plots of land so as to eke out a living. The petitioners has also submitted their applications before the Deputy Commissioner, Dorong district at Mongoldoy, seeking settlement of the land under the occupation, and during the pending disposal of the applications, notice has been issued by the Circle Officer Mongoldoy directing petitioners vacate the land. By the order dated 25/9/2023, the Honorable High Court has disposed of the said writ petition by granting 2 weeks' time to the writ petitioner to submit individual writ petition ventilating their grievances in the matter before the district magistrate Dorong at Mongoldoy. Further, it was directed, if such petitions are submitted within 2 weeks, the same may be considered objectively and be disposed of by a speaking order to be passed as expeditiously as possible, but not later than 8 weeks. That judgment. And my lord, lastly, my lord, another judgment of 2020. Order dated 22/9/2020. Passed in WPC number 8713/2018. In the said order, court observed para 4.3 about the explanation 1 to clause 17 of the land policy 2017. 2009, sorry. Another in para 4.4, the Honorable High Court has observed
If these
about the
if these
clause.
If these are non-reported judgment, please give a copy because
I am furnishing copy. I observe about the clause 14.4 of the land policy 1989 by said order dated 22/9/2020. The Honorable Court had directed the petitioner to submit a representation providing the details they are seeking allotment settlement in respect of the plot along with all the supporting documents within a period of 1 month from the date of the said order before the Deputy Commissioner Shivsagar. While submitting representation, the petitioner shall also enclose the copy of the present writ petition along with the affidavit in opposition submitting by the Circle Officer Shivsagar along with the annexes thereof. Further, it is provided that upon receipt of the said representation, the response number 2, Deputy Commissioner shall consider the same, taking into account of the land policy 2019, the provisions of Assam Land and Revenue Regulation 1886 and other legal and aspects in consideration and shall thereafter pass a reasonable order within a period of 2 months thereafter. All three citations I have submitting. Citation. Your Lordship, kindly produce the judgment. Thank you. If, my lord, they have against their own reservation policy settled a huge plot of lands after a clear order, my lord, then we have been discriminated, my lord. Some similarly situated persons get land. We are poor bhakots of Gormo Sotra, man. Having our family members and no any source of income.
Okay, yes. Please, Mr. Goswami.
My lord, even today also, my lord, the petitioner has not disclosed the actual state of affairs, my lord. First, my lord, the father of all the petitioners, my lord, he was granted, first, my lord, 6 bighas, 2 kathas, 10 lesas land, my lord. That is already in occupation of all of them, my lord. Apart from that, my lord, the petitioner number 1 applied for agricultural land for 3 katha 10 lesa. And under Bosundhara 2,
3 bigha.
3 katha, my lord. 3 katha 10 lesa.
Yes.
On his application, my lord, authority granted, my lord. That has not disclosed, my lord. That is in a different DAG number. That is DAG number is, my lord, 998. Patta number is 532. Then, my lord, petitioner number 3, he already died. His wife applied for land under Bosundhara 2. Accordingly, she was granted 1 bigha land in her favor. Gitanjali Borua. Then, my lord, petitioner number 4, Kripabor Borua.
What is
He
the
was
name?
also granted
What is the name?
Kripabor Borua.
Yes.
He was granted 1 bigha for residential purpose. Petitioner number 1, he sought for agricultural purpose, and petitioner number 3 and 4. 3 already died. His wife applied,
We have been substituted in.
Please don't disturb.
so accordingly granted, my lord. Other two
This is what
petitioners,
class of land?
my lord,
This is what class of land?
this is so for Gitanjali Borua and Kripabor Borua is a residence for residential land, homestead land, my lord. And Sri Premkanto Borua, he was granted agricultural land. And other two petitioners, my lord, they did not submit any application for any allotment.
Petitioner number 2 and 5
Yes,
did not apply.
not apply. There is a format, my lord. There is a separate process nowadays. So in case they require land, my lord, certainly they have to make their application for that purpose. Only on sole ground, my lord, the petitioner is not maintainable, my lord, because he has not disclosed, my lord. First, his father was allotted. Then on their application, 3 petitioners were allotted, my lord. And 2 petitioners till that have not applied, my lord. In case they file any application, authority would have considered, my lord, whether that can be done or not, my lord. And the land, they have been now, my lord, the land has been sought for, my lord, in their project. This is a land, my lord, for integrated office complex, my lord. Only for integrated office complex, certain under DAG number 285, right? That under land under DAG number 285, that has been kept reserved, my lord. And it's a government land out and out, my lord. May I place, my lord, one copy of the job? 285. Right. As per their application, my lord, authority has considered allotted land, my lord. The 285 DAG number, my lord. This land, my lord, they want this portion of the land, which authority cannot give, my lord. So the judgment he has referred, my lord, all are distinguishable in the present facts and circumstances of the case, my lord. And petitioner, except petitioner number 1, all are government employees, on pensioner and government employees. Son of the petitioner number 2 is a government employee. Oshut Borua was a government employee, died. Wife is a pensioner.
This is
Petitioner number 4 is
petitioner number 1. What is his status?
he's
It's
agriculturist.
It's
Agriculture.
Agriculturist.
Petitioner number 2.
Petitioner number 2, he died, Chandrakanta Borua, and his son government employee.
Into government.
Son,
No, my lord, I have no any information regarding this. my lord.
Sir, he may be 100% wrong. Let him complete. He is an additional advocate general.
Oshut Borua died. He was a government employee.
He's P3.
Petitioner number 3, my lord. His wife, Gitanjali, she is a pensioner. Kripabor Borua,
Just a moment.
my lord. এইখানে না গাম্বুয়াটি এখানে কোন কি করে
P4.
Kripabor Borua is a pensioner presently.
Retired government employee.
Yes, and Tilok Borua is a government employee. এখানে না এটা
Who is-
that is
who is
it
Tilak
has been
Barua?
reflected in this
Who is
communication.
Tilak Barua?
Petition number 5.
5. This is the communication, my lord.
Yes, anything in reply, Mr. Barua?
So my respectful submission, my lord, even if they are occupying land here and there, my lord, government cannot go on, my lord, giving allotment in their favor, my lord, wherever they are there.
Yes, Mr. Barua, anything in reply?
My lord, regarding the petitioner number 2 and 3, my lord, son has been substituted by order dated 11/4/23.
All these things I have not disputed, my lord. Nothing I have.
And my lord, whether they have stated that allotment has already been made, my lord. But regarding that, there is no any supporting documents, and as per my knowledge, my lord, after allotment, my lord, before it is a land advisory committee, my lord, then proposal was made, my lord. Thereafter, premium should be deposited, my lord. All these things are not done till then. They have not annexed any documents or furnished any documents.
It was his responsibility, my lord, to
And
disclose
my lord,
the
in
actual state of
Bosundhara, my
affairs.
lord,
Very complete.
My lord.
in Bosundhara, my lord, our case is filed on 24/8/2018, my lord. And during pendency of this case, my lord, some applications has been accepted. If there is a pending court case, they knew about our pending court case, my lord. Persons from their favor, my lord, they have allotted land, my lord, in 2-3 different dark numbers. We have enclosed in our additional affidavits. And my lord, one Durlabh Sharma Pujari, my lord, his land also reserved for that purpose, my lord. We have enclosed their documents. They have allotted him more than 1 bigha land, my lord. There is a documents, my lord. And my lord, one Sushil Chandra Kolita, my lord, he also gives Suresh Kumar Soikia, my lord. He was also allotted land, my lord, from the reserved, my lord. And my lord, may peruse the land potta of Durlabh Sharma Pujari, Annex 4, page 71.
Yes.
Holding 3 নম্বর অংশ 652. This is the land potta allotted to Durlabh Sharma Pujari. This potta was issued on 10/3/06. And next, my lord, annexure page,
Just a moment.
my lord.
Yes.
Then, my lord, next annexure, my lord, page 73. Annexure B. There is a name Suresh Polita, Goromur Sotragaon, Konglabari. Dag number 4, Park. Proposal for settlement of land from that reserve area. By reflecting length of possession.
Yes.
Then, my lord, your lordship may kindly peruse our additional affidavit. My lord. Affidavit in reply, my lord. Affidavit in reply filed on 12/6/2023. Right.
Yes.
And lordship may kindly peruse paragraph 11, my lord. We have stated everything, my lord, how land was settled to others, my lord, from the reserved area. It is relevant only in 119, my lord.
119.
119, my lord. It's a big paragraph, my lord. The respondent numbers 5 and 6 have settled the government land covered by Dag number 3 and 4 under possession of Sri Muktinath Tamuli, son of late Gopal Tamuli, Bhait Khiras, Miyati Patta number. Losses has got.
You see, this is one part of inquiry where I am reading it half-heartedly. The reason is people who have been allotted land, rightly or wrongly, we can't inquire into it because they are not before us. So therefore, the pleasure of reading is not there, number one. Number two, you have heard the Additional Advocate General. He has made a submission that in respect of land of Dag number 3, there's a total of 110 bigha land. 54 bigha still remains the government land and 77 bigha has been allotted. So in 77 bigha which has been allotted, there may be 2 people, there may be thousands of people. So reading the names doesn't make any sense. The question is that if at a point of time the government decides that no more, can that policy decision be questioned by the court by saying that no, since in 1975 you gave someone, in 2016 you gave someone, therefore in 2024, please pass an order directing the government to allot me land.
My lord, in that case, my lord, we have filed representations, various representations.
That's
They
okay.
have not
We have
considered
put
our
it-
any
you-
representation. Lord.
No, this is
All
in response to
representation
your,
approach in
this
our
is in response
petition.
to your submission, whether the court has read paragraph 11. It is only with regard to that I have said. I am not saying anything on merit. You have asked whether you have read paragraph 11. I have told you that half-hearted. Knowing 10 names doesn't make any difference to me. I know 10 names or do not know 10 names, doesn't matter. But the government policy of not giving the land because of reservation, you are not showing us anything from which we can say that the reservation order from the date of after it was passed, thereafter it was violated. There should be a date of passing of that order. After that, there is nothing on record to show that they have violated.
Yes, my
And-
lord, they have violated, my lord. They have given land settlement to many other persons, my lord, only depriving us, my lord. There are various instances, my lord. All documents we have annexed in our additional affidavit.
What is the summation on negative equality?
And my lord, there is also a statement made by the addition affidavit, my lord, affidavit in opposition, my lord. If hearing of some officials doing that, my lord, action should be taken against them. They stated their own affidavit, my lord.
Okay.
At para 15, it is stated, my lord. The deponent Bexto said that regarding the allotment of land in reserve area, as mentioned in para, an inquiry will be conducted soon and disciplinary actions will be initiated against hearing officials. It is a statement on oath by the additional deputy commissioner, my lord, in the affidavit.
Heard.
And my lord, lordships may kindly peruse paragraph 10 and 11, my lord, of my affidavit in reply.
We have told you, there's no interest in reading it.
And we have submitted our written argument.
That's okay.
And we are praying for, my lord, settlement of the land, my lord, or direction for before the deputy commissioner, my lord,
But Mr. D.
to
Boran,
file appropriate application.
counsel for the petitioners. Also heard. Mr. B. Goswami, and additional advocate general for the state, assisted by Ms. M. Burman, and government advocate. Also heard Mr. A. Bhattacharya, and standing counsel for the revenue department. Appearing for respondent number 2 and 3. Advocate general would be for 1. Four and 5, 6. The case of the petitioners in this writ petition filed under Article 226 of the Constitution of India, that they are sons of late Khogeshwar, Khageshwar, Borua, Boruh, who was a freedom fighter. Full stop. They are the residents of Garamur, Garamur, Hotro. Full stop. It is claimed that they are occupying an agricultural land measuring about 17 bigha, 4 katha, 15 lesha, comma, covered by dark numbers 3 and 4 of number 5 lot. Lot LAT, huh? In what is the village name?
Goromur Satra, ma'am.
In Goromur, GRAMUR, Photo.
Gormur Satra Revenue Village,
Revenue village, okay.
under Kamalabari Moja.
Under
Moja
Kamala,
Kamalabari. Moja under Moja Kamalabari.
under
Kamalabari Moja.
Moja, Kamalabari,
And Majuli Revenue under Majuli Revenue Circle.
Majuli Revenue Circle. It is claimed that the land is in the occupation for last 70 years, say 70-80 years, since the days of their forefathers. Full stop. The breakup of land, which is in occupation of the petitioners, are as follows. This you'll get in written argument page 2. Make a pencil mark. Next one. It is projected that the petitioners have made a prayer before the concerned revenue authorities for settlement of the aforesaid land in their favor. Next. The the Learned Counsel for the petitioner has submitted that the entire land was earlier belonging to the Goromur Satra, but by way of its acquisition under the Assam state acquisition of lands belonging to religious or charitable institution of Public Nature Act, 1989, those lands were acquired and were made government land.
59.
Oh, 59. They made government land. First stop. However, the land referred above were held by the forefather and the father and the father of the petitioners. Full stop. It is further submitted that several representations have been submitted before the concerned revenue officials, including the district commissioner and the circle officer concerned, for settlement of the land in favor of the petitioners. Full stop. However, it is the projected case of the petitioners that the government authorities did not take any steps for settlement of those lands to the petitioners. Next paragraph. By referring to the pleadings made in the writ petition as well as in the affidavit in reply, it has been submitted that a large area of land covered by Dag number 3 and 4 have been settled with various persons. And as as no settlement has been made in favor of the petitioners, comma, the petitioners have been discriminated, and therefore the non-settlement of the land to the petitioners is projected to be discriminatory. Full stop. It is further stated that there are several documents on record to show that the officials of the land revenue uh, staff of the establishment of the district commissioner Majuli, which was erstwhile under the administrative control of Jorhat deputy commissioner, right? Had also issued certificates from time to time to show that the petitioners were in occupation of the aforesaid land, correct? Full stop. Referring to the RTI reply received by the petitioners, how it is submitted that more than 77 bigha land, about 77 bigha, 3 kata, 3 lecha land of Dag number 4 have been converted to Miadi Pata land,
And 51 bighas from Dag number 3
and 51 bigha
out of 110 bighas
out
from
of
Dag.
110 bighas are also converted to Miadi Pata land, which is stated to be made after the orders were passed for reserving the land for government purpose.
In the year 1984.
Full stop. In the next, in the by way of an additional affidavit filed by the petitioners, it is projected that the part of land which was held by the petitioners are being developed by the concerned authorities under the PWD, and illegal earth cutting and earth filling works are being done on their land for the purpose of construction of integrated office cum residential buildings. And it is projected that the petitioners are being dispossessed from the said land without following due process of law. So it is also submitted that most of the lands which are settled with various allottees was illegally done, as most of those allottees do not fall into the landless category. And therefore, the action of the state respondents in allotting land within 2 miles of the subdivisional headquarter office, now the district commissioner's office, is also being questioned as illegal action on part of the respondent authorities. Next, according to comment, is submitted that the petitioners are entitled for a consideration of allotment of land in their favor on the strength of their representations. First one. Next paragraph. In addition to the oral submissions, the learned counsel for the petitioners has also submitted written argument, which is kept as a part of record. Next one. Have I missed out anything? No.
Well-
Have I missed out anything
No.
for the petitioners? Have I missed out anything?
My lord, there is a certificate from the Sottadika, as they stating that they are the riots of Gorpur Sotra.
Okay. Just before the last paragraph, right? It is also submitted that the
Sottadika of Gorpur Sotra
the-
issued
the-
letters.
Gormur's Satradhikar, Satra's Satradhikar has also issued a certificate that the petitioners are the riots under the Satra. Next paragraph. The learned additional advocate general for the state has produced the photocopy of. You have also got the original one.
Yes.
There has produced the original. So what is that?
Sita copy, my
Original CETA copy of the of that number
Wait.
285. In terms of directions issued by this court by order dated 12/1, 24/1/2024, which is relatable to the stand taken in the affidavit in opposition filed by respondent number 2.
4.
Huh? Respondent 4, along with the photocopy thereof to be retained in the record. Next paragraph. Referring to the stand taken in the affidavit in opposition, as well as instructions received by him, the learned additional advocate general has submitted that the land covered by that number 3 had a land of 110 bigha, 4 katha, 13 lesa, out of which government land is about 54 biga, 3 kata, 7 dacha. And the rest of the land have been made pata land. Allotting land to the beneficiaries, oblique allottees. Full stop. Which roughly makes 56 biga, 1 kata, 5 lacha land allotted
6 less.
and converted into patta land. Full stop. It is submitted that the argument 4 has a total land holding of how much was it?
77 biga, 3 kotha, 5 less.
Okay, 77 biga, 3 kata, 5 lacha. And
And-
how much is government land?
Government is Miadi, become Miadi 8 biga, 0 kotha, 5 less.
Out of which Miadi land, land converted to Miadi patta is how much?
8 biga, 0 kotha, 5 less.
5 lacha. And the
And the next is government then total 69 biga, 3 kotha, 0 less.
right that, huh? Government land. So.
69 biga, 3 kotha, 0 less government land.
Next, but it is further submitted that the father of the petitioners, as he was a freedom fighter, was allotted 6 biga. What is the land holding to father, Mr. Goswami?
My lord,
What is the land given to father? I forgot where I have read. 6 biga land. What
Yes.
is the total quantity land?
it's fantastic. Yes. 6 biga, 2 kata, 10 lesa in dag number 17, 25, 31, 36.
Just please repeat again. My secretary will write it down.
My lord.
The secretary will write it down. Please repeat
Yes.
again slowly.
Yes, Pedagogue, page 7, my lord. I'm
Hmm.
saying, my lord, 17, dag number 17, 25, 31, 36, and 322 in Gormur Sotragaon village.
Okay.
In that view of the matter, they are not landless people.
So accordingly, it is submitted that the petitioners cannot claim themselves to be landless persons since the beneficiary of land allotment was their own father. Next paragraph. It is further submitted that the petitioner number 1 is purportedly an agriculturist by profession. And despite land being allotted in the name of his father, he also had applied for land allotment under the Basundhara 2.0, right?
Right.
2.0 scheme. And he was allotted 3 biga, 3 kata land.
3 kathas, 10 lesa.
Huh?
3 katha, 10 lesa.
3 kata 10 lesha.
Right.
Okay, 3, not 3 biga,
No, not 3 bigas.
3 kata 10 lesha land. Which is covered by dag number 998
Yes.
of pata number 532, right?
Yes, my lord. 998-532. Correct.
Which is an agricultural land. So it is submitted that the suppression of material facts in this writ petition are not referring to the such additional allotment in name of petitioner number 1. Next para, it is also submitted that insofar as petitioner number 2 and petitioner number 5 are concerned, there is no record available of any application for land allotment being made. And therefore, in the absence of instructions, he is unable to state as to whether any land allotment application is pending with the authorities or not. Full stop. It is next para, it is also submitted that the petitioner number 3 has expired and his wife has been substituted in this writ petition.
2 also expired, 2 and 3 expired.
Okay. But in 2 also you write 2 is expired and substituted.
2 expired on 17.
It's
2
okay, I
20.
don't need those dates. There's no 3, right? They're substituted. And she also applied for land allotment, notwithstanding that her father-in-law had already been allotted land. And the authorities have allotted 1 bigger land, 1 bigger homestead land to Gitanjali Barua, which is covered by that number,
New DAG number 996
pata number
530.
30. Next paragraph. Insofar as petition number 4 is concerned, notwithstanding that his father was allotted land, on his application, the concerned authorities have allotted 1 bigger land for
Yes.
residential purpose, which is covered by that number
New DAG number, my lord, 997.
9 and 7. Pata number
Pata number 531.
5
531.
3531. Full stop. It is further submitted that none of the petitioners fall into the landless category, not only because they have inherited the land in the name of their father, but the petitioner number 2 and his son are both, the petitioner 2 who had expired was a government servant, and even his son is a government servant.
Working 7 নহয় কিন্তু আপনি
The petitioner number 3 who had expired was also a government servant, and his wife Gitanjali Barua is now a pensioner.
As per the communication dated 8 March 2024, that is the order.
The petitioner number 4 is a retired government servant and is a pensioner. And the petitioner number 5 is also a government employee. In this regard, it is submitted that the aforesaid statement is made by him on the strength of instructions received by letter number RM of the 35 of the 2023 dash REV dash MJL capital of the 1460 dash 61 dated 8/3/2024. How it is submitted that the said fact will not be brought on record by way of an affidavit in opposition. In the affidavit in opposition is not there.
No,
Affidavit in
it
opposition
is
is not
not.
there.
Subsequent to the affidavit of opposition.
Full stop. In view of our committee submitted that due to suppression of material facts, the writ petition is not maintainable. Next one. Although the learned counsel for the petitioner has taken pains to refer to the allotment of land given to various persons, but from the entries made in the Chitta in respect of Gormur Hatto village, lot number 5 of Moza Kamla Bari, we find that there is a entry made therein which is made pursuant to memo number NRS. Please, please check it whether I'm referring correctly. The Chitta that pursuant to memo number NRS 9/85/85/3/725-25/5/81 dated (29) April 1984 by the Kumadipati. What would be the English? Mahkuma?
Subdivisional officer, Muhammadipuri subdivisional officer.
Subdivision officer.
Sub-divisional officer,
Kumadipati.
civil.
SDO civil, comma, land falling within 2 miles radius of
Present Deputy Commissioner's office.
present Deputy Commissioner's, District Commissioner's office,
Sorry, District Commissioners.
Not the
Is-
district,
is not
it
the-
should be
is-
SDO civil's office, madam, Muhammadipuri Karjalaya.
no, now it is subdivision, now it is.
Now this year.
Now
Now
DCO.
it is. Which was erstwhile, you see, which was erstwhile the office of the subdivision, is SDO civil. Is restrained from being allotted and settled. Full stop. Therefore, if any allotment of land is made contrary to the said entry in the Chitta, or the said would be illegal and not sustainable, and therefore it would be open to the state to take such measures as they may be so advised. Full stop. Next paragraph. However, comma, when there is an express ban in the allotment of land within the said area, comma, merely because somebody else has been allotted land therein without the sanction of law, cannot be a ground for the court to justify to pass any order directing the respondent authorities to violate their uh, revenue orders and to consider land allotment for the petitioners, because this is not a case where the right of negative equality can be enforced by the petitioner. Next paragraph. The observation of the court as to allotment of land being illegal is only on the strength of submissions made at the bar, and as the concerned parties are not before this court, the observation of this court will not be constituted to be a finding of fact, and therefore the said observations has to be determined by the concerned authorities on the basis of facts available before them. Next paragraph. The fact that the father of the petitioners were allotted land is a fact which is not disclosed in this red petition, which amounts to suppression of material facts. Full stop. Under the circumstances, when the father of the petitioners got allotment of land in the category of freedom fighters quota, they have a right to inherit the land, and therefore the petitioners cannot be considered to be a landless person. Full stop. Next, the learned counsel for the petitioners has referred to the case of these are three petitions, huh? Three petitions. So and so versus so and so. Decided on so and so. Full stop. The said decisions are not an authority on the point that even when the father of the concerned persons were allotted land, they would still have an indefeasible right to be allotted with land, with further land, by treating them as landless person. Full stop. Therefore, the ratio of the cited cases would not apply under the facts and circumstances of this case. Full stop. If the petitioners do not fall within the meaning of landless persons, they would not have an indivisible right to have a right of hearing before the concerned authorities under the Assam Land Policy, 2019. There is nothing contained in the Land Policy, 2019, which should entitle a lot of land. The legal representatives or legal heads of an allotee of land to be a landless person, giving him right to apply for allotment of the government land. On the set two grounds of suppression of material facts, as well as on the ground that the petitioners are legal heads and representatives of late Khogeshwar, KHAGSWR Borua, BORUAH, who has been allotted. What is the land? 6 biga?
6 biga, my lord.
The same land you would copy it from there. 6 biga so and so, that number so and so, so and so.
6 biga, 2 katha, 10 lesa.
Of village so and so. You have it, you can copy it from there. Come on. This repetition is not found maintainable on facts. As regard on the ground of suppression of material facts, and secondly on the ground that the petitioner is not found. Petitioners are not found entitled to be considered as a landless person, so as to give them any indivisible right to apply and be considered for allotment of land. So accordingly, this petition stands dismissed. Leaving the parties to bear their own cost.
My lord, without any due process of law, they meant to evict, my lord, that part, my lord, regarding that part.
Once you are not there, you can't be given, because you are dismissing your writ petition also on the ground of suppression of material facts. So interim order partially stands revoked.
Bless.
Certain order, interim order was there, I think, my lord.
We have revoked it.
Obliged.
Status quo order. was-
Obliged.
Pardon me?
Initially, status quo order was due.
But we revoked it.
Revoked. Obliged.
But Mr. Goswami,
My lord.
Mr. Seke has left. Yes. But there is a constant issue which is coming up before the court with regard to your land policy. One day you'll have to address us, even if there's no matter, you'll have to address us just to enrichment, what you call knowledge on this point. You see, what is happening is that under your land policy, number one, you encourage what you call encroachment by saying that once you are in the land, then only you will be allotted. Correct. So this is an issue which is constantly coming before for adjudication, and is an issue which is always what you call is since it is time and again cropping up, we need an answer to that. Number one, you see, you encourage by your land policy to have an encroachment of land, and there are two classes of land which can be encroached, which are wasteland or otherwise non-cultivable land. Now, under your land policy, you also have a policy where agricultural land can be held, and under you give two protections. Number one, as an adiyar or as a tenant or rayat, you give them certain protections. And you permit an agricultural activity on a land by a tenant who's not otherwise a landholder. These are two classes which has come to our notice. Now, in one set of cases, you go for a regular notice for eviction. In some others, lot of cases, you go under 18(2). Now, in 18(2), there are various judgments of this court interpreting how 18(2) can be interpreted. But the fact is, in one set of cases, you allow them an opportunity of being heard. The second set of cases, you don't give them an opportunity of being heard. You say that 18(2) is that once there's an encroachment, you go out. Now, since our first days as a student of law, when we were at college for the first time, we have heard about the ingrained policy of a right to be heard, audio alterum partem. So here, the question of the court starts. Number one, if I have to be allotted a land, I will show my right to be allotted that land. Correct. And then you don't give me a hearing when it is under 18(2). Therefore, you are taking away a right where I can establish, or a party can establish, not I, but party can establish that he had an indivisible right to be there. But in this case, they are saying 70, 80 years. 70, 80 years if you are holding a land, you take over the land under this act. I have my own doubts about the manner in which things were done under this act. But then you don't give them a hearing under 18(2) to establish the right to be staying there, even against the government. Article 65 would apply after 30 years. Because the Article 65 does not distinguish between a government and a private individual. There's only a period of limitation for government, you have 30 years. So if in this case, Mr. Barua is showing 70, 80 years, definitely that is something which will have to be taken into account. So how far the policy of the state, when you see what has happened, we have got writ petitions here. That's why it's looking at thoughts. Number one, you evict somebody and then you give it to somebody else. You allot the land to somebody else. It has happened. And these actions of the state were defended here a few days back when matters came up. Now, how is that possible? That means you go by the face value. X is there, evict him. Y is there, give him. Y may not have a indivisible right to be allotted land there because he is not in possession. But then you say you can give it. So one of these days we propose to give a notice to you or the Advocate General and then have these issues heard. The right to be heard, how far that can be prevented or taken away from a citizen. Because somebody else can be given that same land. And you are saying that you are reserving the land for, say, for the government purpose in this case. You're saying that you are reserving land.
They have also.
And you are giving allotment of the land that is showing in this petition. From in 1984, you have been allotting land.
They have also stated taking action against the hearing
So
official.
that's why we said,
Yeah.
but we can't give an adverse remark without hearing someone. So that's why we clarified. But you say that it can go ahead. These are issues we'll have to address. And then there is another aspect. Although it may not look good to be spoken here, but you will find a pattern when you look at the places where these evictions are being carried out. You can identify people with regard to race, religion, and class of people who are being evicted from these lands. It will show you a pattern. At least to us, when we hear matters, some patterns are found. I don't know, as defending the state, whether you see that pattern or not, we don't know. But we find a definite pattern. So
For admission, item 3 to 7.
The last occasion, my lord, they were asked to file affidavit, and they have received the instruction, and that was by way of affidavit, it has to be submitted by them, my lord.
But I have prepared the affidavit, sent it for vetting. It will be coming.
the 2019 matter.
My lord.
Yes, but Lordship may give me some sort of accommodation, we'll file. Next week, can it be?
Regarding non-payment of contractual bill, they're making an inquiry, probably inquiry they have completed. They say that the inquiry has been completed and they have to produce before this on by way of affidavit. So lordship go by the order that is 6/3/2024, then it will be clear, my lord.
But these letters which you are producing, it undermines the credibility of your institution. Can you understand what I'm saying?
No.
No. You see, instructions to you is which we find from these letters which we have flagged here. One is communication dated 23/11/23 by the Joint Secretary Revenue to you. Correct. We look at its contents. It says that you want to assimilate, to examine the report by the Commissioner Lower Assam Division, CM Special Vigilance says to assimilate the facts. If after getting report you want time to assimilate facts, it means very serious people are there in your office. You're so serious that they look at the paper for the entire day and then go away. You don't have people who are working. You have serious people who look at the file.
After these two reports, my lord.
No,
the
I understand,
department
but how much
constitute
time?
Another committee, my lord.
No, I understand. There is one committee to give a report, another committee to examine the report, third committee to find out whether the examination by report by one or two is correct or not. So you're looking at the file. So it is endless. So why instead of waiting for an affidavit, we give a direction, you make the payment?
So ultimately decision has been taken, my lord. Instruction I have, but
Let us see what your instruction is.
last occasion I produced.
But the impression we are getting is that once it's a high value bill, 14 crores, correct? 14 crore. Once CM Vigilance and all, everyone are there. Whether office will get profit out of it or we don't know. Otherwise, people are very happy in passing a huge amount of bill. I don't, this is only an impression I'm gathering. I always digress. It's a Hindi song. सीधे रास्ते की ये टेढ़ी ही चाल है. So at times I go astray. So you'll have to excuse me for thinking those things. Anything, is there anything on record to show the coordinates where the flood relief, sorry, the flood control measures were taken? Do we have the coordinates of that area? No,
Hmm.
we don't have. I think we'll have to tell your government something. If you can get information, number one, we need for some reasons these coordinates of the places where this work was done. It's number one. Number two, within that area where these flood control measures were taken, is any part of that land covered by any mining area? This is not for their purpose, just for my education, for my knowledge. Whether this any part of this is within the mining area.
তার বেশি সাপ্লাই দিয়াটো হয়।
one corner, one core
I'll show you why I'm asking this question. In your, in this South Salman Mankachar area, type of mining activity is 3,01,100 cubic meter for sand. Gravel is 1,92,003 cubic meter. Stone is 5,40,060 cubic meter. Earth is 2 lakh cubic meter. So therefore, the area where you are having, it's I may be 100% wrong. The flood control measures where you are taking, where you are doing flood control measures is within the mining area, and therefore you are not finding the measures taken at the site. I may be horribly wrong. I don't know. But since I have a bad habit of
Yes.
looking things here and there, you can find out because your clients will be able to tell you
My lord.
on the mining area. If it is nearby, then we know the answer.
Yes, well, that's correct.
Right, correct.
I'm from that locality.
Okay. You see. You don't need a,
Stones and the sands.
it's a general idea if you
He's
have.
from that locality, he knows, man.
No, that's why I'm asking. You see,
Yes.
there are few things which trigger,
Yes, yes, yes.
few
Yeah,
memories.
correct, my lord.
there are few things which trigger my memories. Because I was there where you were
I
studying
know, I know.
some time ago.
I
So
always
therefore-
depend on your lordship. That-
So you adjourn the matter?
Right.
How much time?
1 week, my
1 week.
So
You have
only
to do
for
it?
vetting, he says they are already with this everything clear, only for waiting for vetting.
yes.
No, this 7th is coming, that's why. Make it 13th then.
My,
13th or we can do one thing, if they file their affidavit in opposition, you will like to file a reply if required. We'll say it within the
in the
file it.
meantime, if required, I'll, in the meantime.
Okay, so you'll give them the affidavit by 10th?
Right.
Affidavit in opposition, if any, by 18th, sorry, by 17th. You're listing it on 21st of May.
My,
So A Bhattacharya standing for the Revenue Department submits that the affidavit in opposition has been sent for vetting. And it will be filed within a week. In view of the ensuing elections, let the affidavit in opposition be filed by 10/5/2024. Reply if any is filed by the petitioners within 17/5/2024. List on 21/5/2024.
deeply.
And this is right, Mr. T.J. Mathur, Senior Counsel, requested by Mr. R. Islam, Counsel for the petitioners. You for all?
Yes.
No problem.
Okay.
Item 8.
Please, your lordship. May I draw your lordship's
Please
attention?
button up your coat.
My lord?
Button up your coat. Eight.
May I draw your lordship's attention to two orders before making submission? 8th November 23 order, if your lordship could take up.
Item 8. Yes. Order dated
8th November 23 and 9th and 11th December 23. Kindly have 8th November first. The primary grievance of the petitioner is that there is inaction on the part of the respondent authorities in mutating the name of the petitioner in a parcel of land covered by so-and-so, situated at village Durga Sarovar. The petitioner has submitted that the petitioner had purchased the said parcel of land by registered sale deed. Learned counsel for the petitioner has submitted that though in view of pendency of a writ petition so-and-so, the process of mutation was not undertaken earlier by the respondent authorities, there is no impediment as of date to undertake the process of mutation in respect of the parcel of land purchased by the petitioner in view of disposal of the said writ petition. So-and-so shall obtain instructions as to whether the process of mutation in respect of the areas wherein the petitioner's parcel of land is located is kept in abeyance, and if yes, the reason for keeping the
No,
process
this is kept under abeyance. This mutation will not be done.
Yes, Milord, actually there is an order. This the
No, there's a judicial order of this court.
Milord, division bench's order. May I just
Yes.
hand over that?
I'm aware of it.
Milord, but kindly see the next order, 11th December order.
No. This has to be kept in mutation because of the fact that the land records are lost.
No, I mean, that was their stand initially that the map is not available.
No,
But
no,
the
the entire
underlying-
land revenue records are lost. I'm aware of it because I have
Lordship
heard that
in-
matter substantially.
In other matters, lordship. So with the-
I'm aware of it. The land of Kamakhya, land records of this Kamakhya is lost.
Yeah, but my land is in Durga Sarovar.
Durga
which is
Sarovar is
across
again,
the road.
you see, we know that. Durga Sarovar land is a part of Devalai land.
That's they claim, Milord, and the writ
Not
petition-
they claim. I know it. It is.
But they have admitted in their counter affidavit that has been filed now that my predecessor's title
Please
is acknowledged
understand.
by them.
I live under the what you call protective umbrella of Ma Kamakhya here. So therefore, when it's a Devalai land and it has come to judicial notice in course of proceedings, I'm aware that the land is lost and therefore there's a direction not only by the deputy district commissioner, but also by this court not to do it. Let us see your order, what you're trying to show.
This matter was pending since August, and actually it had not
No,
come
this
to
matter
light.
is pending for last about 4 years.
No, there was a writ petition which was pending since 2003, where an interim order was passed.
There's a
So that
PIL.
was finally
PIL
is also pending.
It's pending. I'm aware of it.
that
If I don't know it, I would not have said it.
so that petition was disposed of on October 27th, October 22, against which this writ appeal has been filed. And my lord, they have now mentioned this in their.
No, this is in a different aspect. Here, what had happened was this order,
Was putting to retainable areas. my lord.
retainable areas.
Yes, yes.
So this is only retainable area. The retainable areas has got nothing to do with the issue of the mutation of land being.
So there's
in
an
the
interim
area.
order pertaining to mutation. my lord.
No,
Well, let me just see the last page, my lord.
no, you bring us the updated facts of all these cases. The earlier writ petitions are there. Please examine if all these matters can be taken up together. Because stray orders here and there may cause some issues. What is,
Additional Advocate General T. Mozumdar is appeared in some other cases.
no, we want in sequence. Number one, the various orders passed in these writ petitions and PIL. That's one. The second is that the status of reconstruction of the records.
Record.
Because what had happened was in one of the writ petitions, it was a submission was made that the original land records were brought to this court. And it is from this court that the land records were lost. Thereafter, this not returned. Mr. Saikia, I take advantage of your presence. I just want to narrate something.
Lordship.
Nothing to do with this case.
Lordship.
It's a general submission.
Lordship.
This matter relating to the land records of Kamakhya Devale, I dealt with it in one of the matters which were listed before me. So far as I remember, these were about 2 or 3 years, at least 2 years back. So I may be wrong in narrating the sequence, but for that, please bear with me, even if I am wrong. What had happened was, there's a PIL and a writ petition going on in respect of two issues. And the third, I forgot. There's two issues are, number one, the retainable land of Kamakhya Devale after, what do you call it, in terms of that 1959 Act.
That has been disposed of. That writ.
No, I don't know. It's just please let me narrate. I may be wrong. I told you, I'm seeking an excuse before I'm making a submission. This retainable lands were one of the issues. The second the second issue was that the various people are trying to mutate their names in the land, and the land records were lost. Therefore, there is a judicial order of this court, as well as orders by the district commissioner, that till the reconstruction is made, the transfers of the land would not be mutated. Now, I may be wrong on facts, please excuse me. Now, what has happened, in one of the writ petitions, it came out that the then government advocate had produced the original land records before this court in consistent of proceedings. And thereafter, it was lost or misplaced, and the original land records are not there. So, number one, since the land belongs to Kamakhya Devale, I have an interest to see that that the land records are reconstructed. That's one. Now, the second part, this is only for the first part. I'm requesting you. The second part is that if things are made available, then perhaps the mutation and all, which is closed for several years now. 2003, he says.
2003, the order was passed, and 2007 and 8, I purchased the land, registered sale.
So now what is happening is that citizens who have purchased land, rightly or wrongly, their rights are being affected. So therefore, these writ petitions are coming up. And according to me, if we defer these issues for tomorrow,
It will not help.
So although Mr. Handick is there, but I just want to keep you abreast that this is happening. So, because at times you have interactions with so many people,
Lordship,
will
I'll
have to put
definitely give the
information.
updated information.
not
and-
for this, not for this case, but
Yes.
just for your, just for your.
And for public
knowledge.
interest also.
So that is why we require.
I'll
this
definitely look
information.
because a PIL I'm handling now regarding the construction of the Kamakhya corridor. There is a PIL.
Hmm.
So this morning also I had a discussion on that.
Okay,
So I'll find out, Lordship.
Sure.
This was not known to me that land records were lost.
land records.
Yes, Lordship, I'll find it out.
So
And
if
whether
they-
it was reconstructed or not, or if not, then what is the
and
step?
part of these records are still in that bunch of debt petitions. And PL were tagged together. 2 or 3 matters are tagged together.
Lot.
But I won't remember those things because I did not retain those information. So it's just a general idea I'm speaking. I may be incorrect in the sequence which I am.
Lordship, I'll
using.
definitely get an updated thing. And in one of the case, I'll apprise this honorable court.
That's all. I
On
just
this
wanted to bring it to your
Lord.
knowledge. Not required for anything else, but
Lord.
still for information.
Highly obliged.
So we fix it within what time so that you can get this information? Mr.
Let
Andy?
it come after maybe 17th of this month.
17.
17th. 17th is a Friday.
Yes.
I'll appear in this case, Lordship.
So we pass a formal.
Yes,
Request to
yes,
the
sir. Yes,
Advocate
yes,
General
Lord.
to-
Yes, that let it be formalized.
But Mr.
Abir Pukan,
B. Fukant and counsel for the
Abir Pukan.
E. Fukant and counsel for the petitioner. Mr. J. Andy Leonard, standing counsel for the Revenue Department.
I am for a state.
For the government advocate, and Mrs. P. R. Monto Leonard, standing counsel for the Revenue Department. Next panel. It appears that the original land records of Kamakhya Devalaya cannot be traced out, readily traced out. Full stop. In this case, the land in question is covered by Revenue Village, Durga Sarovar, and a large part of the land of Durga Sarovar is also stated to be originally a part of Devalaya land. Full stop. In that view of the matter, we request Mr. D. Saigal and Advocate General to appear in this matter for the state so that the issues arising in this requisition can be resolved judicially. Can be resolved in this petition. Full stop. The learned standing counsel for the Revenue Department shall provide all the relevant materials to the Advocate General and also make an attempt to obtain updated information regarding the status of the land records relating to Kamakhya Devalaya as well as land of Durga Sarovar village, Revenue Village. Anything else?
Your Lordship, the retainable area issue that was disposed of.
No, retainable we are
Yes.
concerned.
On the
It is in-
records being lost, yes, my lord, that has to be looked into. And in fact, your Lordship, there's an order of 11th December also, which records what your Lordships have just stated.
Okay.
Let it come on 17th.
Next
May I
one.
request for 21st?
21st. Let us see the convenience of the
It was
Advocate General.
little, then could it be little bit earlier than Lordship? Maybe if my friend has,
17th is fine. I'm outstation, your Lordship,
Okay.
but I'll join through VC if that is.
Okay, yes, we'll do that. Because we'll have the preliminaries first, then
Yes.
only it can be heard.
Absolutely,
We'll just understand the preliminaries.
absolutely.
List on 17/5/2024.
Highly
As per the court permits the counsel for the petitioner to address the court through video conferencing.
Deeply obliged.
Okay.
The landowner is sitting here, Lord.
You have a very good observation. Yes. Yes, Advocate General is there. That matter. Your item number was
Item
12 and 13.
13 and 14.
13.
13. There's a new case. Motion.
A new case has been filed, so we'd like to file a response to that, but basically relating to the same issue. Same issue.
We're challenging the DC's order whereby representation was rejected. They will
Okay.
file my learned member to file response.
But Mr. Didas, counsel, assisted by Mr. K. Talukdar, learned counsel for the petitioner. Also heard Mr. D. Saigal, learned Advocate General, assisted by Ms. M. Burma, learned Government Advocate, appearing for all the respondents. Next paragraph. The issue notice returnable on
17th, let it be also 17th of this
There
month.
is only one problem, no seven.
Oh, my friend will not be here.
So anytime after 28, 20,
After 20th, it will be, then 27th,
27.
okay,
not 27, 28.
28.
28, 5, 2024. As the learned Government Advocate accepts notice on behalf of all the respondents. Issuance of formal notice is dispensed with. So, however, extra copies of the writ will be served on her in course of the day or
Yes,
by
yes.
tomorrow.
Now, it is.
In
now-
course of the day. Okay. So list on.
We are not appearing for respondent number 9. 9 is Guwahati Biotech Park.
Okay, 1 to 8. You say, huh?
We'll take steps.
The petition shall take steps for service of notice on respondent number 8.
Gosala
By Mr. Kosi Dedi,
Gosala Kothari.
as well as by way of Dasti. Make service by Dasti also.
Yes, yes,
because
no problem.
by way of Dasti, by routing the process through the registry of court and upon service and affidavit of service shall be filed prior to the next date of the state. Okay.
My
Yep,
next
yep.
case, there is an interim order. That will
Item
come, item 14,
Item 14.
interim order. That's the same.
Pleadings are complete. Here
Pleadings
also.
are complete. Pleadings are complete. Board matters.
This-
tagged
this is
together.
also
That's why we file an
Same.
affidavit and both the
Yeah,
matters
both
can be.
matters tagged together.
Okay. See, so. In this. As readings have been exchanged, that this matter was listed on 28, 5/2024 for hearing. For hearing.
Yes.
Yes, for here.
Oh, I said no, the rule has not been issued.
My lord, admission, it can be disposed
In
of.
admission, no?
In admission still.
This is the admission stage on 27/5/2024, along with WBC 2288 of 2024.
The interim order will continue. in this.
Interim order passed.
Till that.
Shall continue
that.
till the next date of listing.
Whenever
Highly
I am
obliged.
I am with him, all big cases, we joke each other. We don't take it any
Here, I
personal.
have seen the
We will-
first paragraph. He has 2 cows and that is creating the problem. I said to her that we have a big Gosala. If those can be transferred to the Gosala, then this problem will get
No,
solved.
That he told me.
Mr. Saikia, we read it in our school time. The story of what is it called? I forgot. Venaki Honkar. That story it arose out of a cow. Cow and a what do you call cat.
Cat. Here, 2 cows. At the end of the day, I do not know, the cow has to come to his house. Highly obliged.
Item number 12, there is one matter, my lord. 12, here, my learned AG is appearing in this case. My lord, you can fix any, your lordship is saying
17th lordship.
17 and
17.
not 17.
Oh, 17.
There
This
is
matter
28.
also come on
28.
28, same day.
Both sides, same.
There is the interim order.
Due to paucity of time, the matter could not be taken up for hearing today.
Yes, Lord. Yes,
List on
28.
28,
8/5/2024.
28, 28.
28.
28. Interim order passed for this time extended till
Till then.
date of listing.
I'm deeply.
Highly obliged.
Item 10 for hearing.
May please your lordship. Just now. In this case, we have no solution. You can only say that you can give secondary evidence of what you call, even if the document check is missing. If you have to give an evidence, you can give it by what you call by way of secondary evidence.
Secondary evidence of my lord, the signature has to be proved, but FSL report is there. But signature original check is not there, my lord. No,
But then-
without original check, where the secondary evidence will come in, my lord? Because it is the question of original check.
But then we have no solution to it. It can't be.
My lord, the strict liability comes upon the government, my lord. Strict liability will come upon the state, my lord. For their negligence, a petitioner, a citizen cannot suffer, my lord.
Where is the document of seizure of the that check? Where is that document of seizure of check?
This is with the police, my lord, that is maybe in the CGM court, my lord, Caesar. Because here the case is what, my lord, if your lordship goes to the order dated 24/4/17 by Justice Suman Sam, it will be crystal clear, my lord. And the inquiry was constituted, and in the inquiry it was found that the check was neither placed before the CGM nor in the Malkhana. And the police,
No. You see, the question of a document being in the Malkhana must precede with a seizure.
Caesar, my lord, your
Yes,
lordship
sir.
will see the report, my lord, which the judicial inquiry was conducted. The report was dated 7/6/15, my lord. It is given by the session judge, my lord.
Yes.
That is there, your lordship will go through that, my lord. And it was found that,
No, here it says, I've seen that, I've flagged this.
yes, my lord,
Here it says that
it was
Uh,
missing.
no. It says there was no instance of the check in question being produced.
Yes, my lord, they have stated, my lord, your lordship will see
I've seen
letter
that.
dated, the district judge letter dated 7/6/17.
Yes, I've
When
seen
it
that.
is last part, what it says, further, as per the report submitted by the prosecuting inspector, Guwahati, flag B, there is no evidence of receiving the check in question in the court of.
No, there's a communication here received from the second session judge.
Yes,
However, as per the communication received from the SI Prabhulla, from the dispute PS, the check in question was misplaced during the time of shifting of the police station. There's a clear finding of the session judgment after inquiry. That they never produced it before the court, Malkhana. It is missing from the police station.
You see, that's why you are saying, you see, this is something, I told you that, you see, this is something which I have flagged.
Yes,
Correct.
yes.
Now, if you read the enclosure of this letter, which is the Office of the Chief Judicial Magistrate's letter of
Ah.
12/5.
Mhm.
Now, here you will find somewhere it is written that the check did not accompany the charge sheet.
But if the charge sheet is not accompanied, how they got the accused got the acquittal, my lord?
No, we don't know about that.
Yeah, that is judgment is there.
Sir, Bhattacharya, please try to understand. We can't know that. That's why we are, the only question I'm asking is where is the document of seizure?
That we have to call for, my lord, then from the CGM house.
Because out of this file, I've already asked you one question.
Yes. So your lordship will call for CGM.
Okay.
From the CGM. Or but from the police station also. Concerned police station.
Where is the judgment of
One
acquittal?
thing is sure, lordship, the certified copy they have obtained, it was obtained from the court of the CGM. Lordship. The certified copy of the check.
Certificate you will not get. Where is that? I don't find that track. I don't find that track. Where is
They
the,
have obtained the certified copy from the
no, under the criminal, if he has got his wonderful person, but you see, under the criminal code rules and orders, a check not be, a check not being a official document for which a certified copy can be issued, only a non-certified copy is issued in the criminal code rules and orders.
But even in lordship, in our affidavit, lordship, we have mentioned all these things, but
No, what to hiring people is
I don't know if he's got it. I
Yes,
can't say
yes,
anything
yes.
because this is something I have not read. But this I can show it from here. That a document, you can't have copies.
whether this can be, this certificate copy cannot be treated as a.
certified copy তোমার signature মিলে certified copy গুলো signature মিলে FSL report আপনার বাকি ছিল না এটা তো অরিজিনাল জিনিস যখন দেখানো পাচ্ছে
FSL report তো আছে আপনার।
FSL report আছে না বাকি ছিল না
FSL report to have আপনি তার exhibit করবো। Why it is to be exhibited again? Why it is to be FSL again?
আপনি FSL report যেটা মাঝে ঠিক করে বলে দিবা চেক করবে সেকেন্ড FSL report কিন্তু দিছে exhibit 1 2 1 3
এইখনকে আপুনি how এইখনকে production Is it not a certificate? FSL report কিহে আজি আকৌ FSL কৰিব।
FSL report to execute they have to complete.
Yes, FSL from yes, it is written by us.
It is written by us. Total original एक बार तो मन जाना
Direction there.
ये डायरेक्शन है
এতিয়া আপুনি এটা কথা শুনক। আপুনি এটা জাগা সাক্ষী দিলে, সাক্ষী এজনৰ সাক্ষীটো আপুনি দিলে সাক্ষীটো মৰি থাকিল। আপোনাৰ কি সেইটো সেই সাক্ষীটো
Yes,
সাক্ষীটো কাৰণে দিলে
Mr. Sharma, let's do something.
technically
You first turn to page 44, there's a flag. Rule 16 down below.
Lordship.
There are two concepts which go together. Number one, a document which is exhibited. For that, you can get a certified copy. But copies which are themselves copies can't be given a certified copy. Therefore, you are given two copies. Now turn to page 50.
40. 40.
40.
Yes.
No, sorry, page 50, 50.
Yes, 50.
40.
Section 40.
Huh.
All copies, whether certified or answer must be carefully examined before issue by a sterilized.
Right. Now come to page 51,
Lordship.
44,
Lordship.
note 2.
In courts as subdivision of behavior. Lordship.
Correct.
Lordship.
So elsewhere it is there, but I don't remember, I forgot it. There's also a provision where you can get an uncertified copy. So therefore, a document which is a part of proceedings, for which you can get an uncertified copy in a criminal trial. And then there's a bar at page 40, you'll also find the strangers in a criminal proceedings cannot get a copy.
Lordship.
So therefore, there's a bar. So that's besides the point, but that's why I said that if he's got it is very good. Normally, it should not have been given, certified copy. If certified copy is available, what you call, that means in the court it was available. That means only then certified copy can be issued. But from this communication, this flag which I put up
That is by the session judge, Lordship.
by the session judge. Now he says that it was not accompanied with the charge sheet. So if it is not there, that's why the
That
question.
is the, in our affidavit, we have specifically mentioned that it was a part of the SRC.
I don't know.
So the Lordship, that, so I do not want to,
No, that's fine. We will call for that record.
Lordship.
It's proceedings of which case? All sides are represented. It is observed that while your affidavit is of which authority? Supreme Police?
Yes, Lordship.
The Supreme Police, Kanpur Metro.
No, Lordship, the affidavit is shown by the as senior superintendent of police,
Where is
City
that?
Guard.
When did you file it?
The date is not mentioned here, but it's by Anand Prakash Tiwari,
Okay, number 3.
number
Yeah,
3.
that-
Thereafter, Lordship, we have again filed an additional affidavit in opposition. That is by Jayant Singh,
Jansi.
additional affidavit.
additional
By
affidavit, but
respondent-
the
By respondent number 3.
no, respondent number 3.
Yes.
Both the affidavits were filed by the respondent number 3.
Respond number 3. Okay, we got it.
But yeah, but I am relying on the affidavit in opposition filed by Anand Prakash Tiwari. In page number 3, Lordship, internal page number 3.
It appears from the
In
conjoint reading of affidavit in opposition filed by respondent number 3
in page 3,
and additional affidavit in opposition
Lordship.
filed by respondent number 3 and the contents of the letter under memo number capital BJK oblique 3198 dated 7/6/2017 issued by the District and Sessions Judge Kamrup Metro Guwahati to an address to the Deputy Registrar within packet judicial JUDL -Roman 1 of this court. It appears that while the stand of the state police is that the check in question was forwarded to the court by,
This sentence we have, may I read, Lordship?
yes.
In internal page number 3,
I've seen that a charge sheet along with case diary.
along with the case there and the seized documents, etc., were forwarded to the court of the Chief Judicial Magistrate Kamrup Guwahati through the prosecutor in so and so under proper dak challan. Thereafter, Lordship, if we, Lordship may come to the additional affidavit.
It's okay. We are just, we are calling
Lots-
the records. I'm just
lots-
making a
lots-
narration why it is made.
Lordship.
The consent check was forwarded along with the charge sheet to the court. The stand of the district judiciary is that the check, there's no instance of the check in question being produced before the court of Chief Judicial Magistrate Kamrup Metro Guwahati. Full stop. Therefore, to ascertain the to ascertain the to go to the root of the matter, the court finds that the records of GR case number 5023 of 2005 is required to be produced, perused. Accordingly, the registry shall call for the records of GR case number 5023 of 2005 arising out of dispute PS case number 1131 of 2005 from the court of Chief Judicial Magistrate Kamrup Metro Guwahati. But this will take some time. I am giving a long date.
Lordship.
The reason is you have seen the court record there.
So 2005, Lordship. Yes, Lordship.
No, it's not a question of 2005.
But even
There's
then,
no
Lordship, it
space.
is-
If you go there, then you will find out.
The judgment is
Yes,
having annexed, my lord. The judgment of the GR case is being annexed in my read.
No, we don't know from there.
Certified
27/5, 27/5. They don't have space. The reality of that court is that the records are dumped in the file and there's no way to track it. The
CGM code.
in the CGM code. Second floor, it's been stacked. It's in a very pathetic condition. And the documents are untraceable. Because of the fact that those roofs had fallen, it had to be suddenly shed and dumped. So therefore they have dumped it without keeping a track of what is where. And now they are unable to find it. 2 lakh case records.
Lordship.
So,
After the
oh no, not 27/5. 27/5, we have a matter fixed. 305. No, 29/5.
29/5.
29/5. There's a, sorry, in 27, there's a matter fixed.
29/5.
Wednesday.
That is Wednesday.
Lordship.
Because we'll have to see the records. We're not
Yes,
hearing
yes,
the
yes,
matter on the
yes.
day.
Item 11,
this 11 has to be adjourned.
My lord.
You won't have time. It's still adjourned. Just a moment. But what is the stand you're
11,
taking?
my lord, after going through all things, my lord, I have to fairly submit, my lord. After next, I have to concede, my lords. These people, though it's not a heritable right, but they should have been given a consideration with, before substituting them with other settlers, my lords.
We send, remand the matter back to the.
That can be
to-
done, my lords. That-
To re-examine the
Yes,
matter,
yes, yes. And
giving him an opportunity of
yes,
hearing.
yes.
Okay. It's good you took a fair stand. Okay, I'll pass orders in the chamber.
I had got in one instruction, my lord. That doesn't indicate that any kind of consideration is given to them.
Okay,
How that was passed, we don't know.
it's okay.
We can fix it some other day, we can pass orders.
Try to dictate whatever it can be.
Yes.
2 minutes, because now it won't take much time. But Mr. P.J. Saikia, counsel for the petitioners, and Mr. D. Govil and as planning counsel for the forest department. Appearing for respondent numbers 1 to 4,
1 to 4.
and Mr. S. Chauhan, and counsel appearing for respondent numbers 5, 6, and 7. Next page. The case of the petitioners is that they are the legal heirs of SCW, SARANG, Mahili, MAHILI, and they've been residing in the land allotted in the name of their said predecessor in interest in the year 1952. Stop. It is projected that from a RTI reply received from the Public Information Officer from a Divisional Forest Office, Nagaon, from a South Division, from a Hujai, that the names of private respondent numbers 5, 6, 7, and 8 have been recorded in respect of the said land. It is projected that the entry of the names of the private respondents is in violation of the provisions of the scheduled tribes and other traditional forest dwellers within bracket, recognition of forest rights bracket closed, Act 2006. As the representation of the petitioners before the respondent authorities have not been considered, the present petition has been filed in Article 226 of the Constitution of India. Next, please. The learned counsel for the forest department, as well as the learned counsel for the private respondents, have both opposed the prayers made in the writ petition. However, on a pointed query of the court as to whether there is any record of the petitioners being heard before the entry of names of the private respondents in respect of their said land, their said land which was allotted in the name of their grandfather within bracket predecessor in interest, comma, the learned standing counsel for the forest department has submitted that he has not been provided with those documents. Next paragraph. As the court finds that there is nothing on record to show that the petitioners were given an opportunity of being heard before the name of the private respondent numbers 5, 6, and 5 to 8 were entered in respect of part of land which was originally claimed to be allotted in the name of Siu Saran Mahili. The court is of the considered opinion that the would be the authority to hear it? Which is the authority to hear it?
DF4, madam. The respondent number, madam.
Please with the
DF4, madam. So
Divisional-
respondent number 3, madam.
Divisional Forest Officer, Nagaon, South Division, Hojai. He has to hear both the petitioners and the respondent numbers 6 to 8. In connection with the representation filed by the petitioners, so as to determine the entitlement of the parties to possession of in respect of the said land, which is stated to be land measuring 12 bigha, covered by DAG number 175, which is located under Kaki range, KAKI range, within Rampur Forest Village. Stated to be allotted in the name of SEW, Saran, SARAN, Mahili, MAHILI. Projected to be the predecessor in interest of the petitioners. Full stop. The next paragraph. In order to facilitate the said hearing, it is provided that the recording of the said land in the names of private respondent numbers 5, 6, 7, and 8 shall not stand as a bar for the divisional forest officer within bracket respondent number 3 to hear the rights and entitlement of the parties by giving opportunity of hearing to both sides and pass necessary orders. We also provide that the adjudicatory orders which will be passed by the divisional forest officer, Nagaon, South Division, Hojai, within bracket respondent number 3, would have a overriding effect on the. Where is that RTA reply page?
My lord. 23, my lord.
Page
23.
23.
Yes. Translated version. Original is my lord, page 20.
We provided the orders related to allotment of land in the names of the private respondents. See, that policy is down. Is it the order for this? Then I'll see. This, I don't want this order to be construed that this order can be overridden.
Yes.
So I just wanted to keep a check and balance. This adjudicative order should have an overriding effect over the allotment orders, if any, passed by the
Respondent
respondent
majority.
three.
Some time limit, my lord, and some protection also to the petitioner
Okay.
still disposal.
Yes, yes.
It shall be done within a period of how much time?
2 months, my lord.
In a period of 2 months from the date of production of the certified copy of the order. Next paragraph, as both sides are represented, comma, the petitioners and the respondent numbers 5 to 8 are directed to appear before the respondent number 3 on when Mr. Chauhan.
In fact, I have the list notice go my left from the DA.
No, then there will be a delay. We'll have to communicate it.
আজিবা 10 দিনৰ পিছত গুচি যাওক আজিবা 10 দিনৰ পিছত লাগিব
27/5/2024. This should not.
Communicated to 5, 6, 7, 7 months. Order passed, my lord. To the my lord also, copy will be served to 5, 6, 7, 7.
No, they will not be served.
আপনি থাকিবেন
They will not be served because you are there.
Yes.
They are my lord, but they are not generally supplying the order.
Pardon me?
My lord, they do not supply the copy of the order. Unless there is.
Which order?
My lord, if they have to pass any adverse order or anything, my lord, that copy may be, my lord, provided to parties.
No, we are giving a date for appearance. That can't be. We are not holding a marriage of my daughter.
Yes.
We will give invitation by hand and then go. We are not conducting a marriage. No.
My lord, I have, my lord, doubt, my lord, if any adverse order will be passed, my lord, that will not be supplied to the private respondent.
No. You see, if I am, if you are a party in the proceedings, definitely you will get a copy.
My lord, we have done the experience of so many certificate copy or anything.
Okay, final orders, if any, passed by the authorities, shall be communicated to the
parties.
Okay.
Some protection, my lord, till disposal of the my lord, entire process, status of the petitioner should not be disturbed.
Yes.
Okay.
Such prayer is not there, only representatives.
না না interim orders
Interim order is already there. passed
there's a-
by.
Interim orders shall stand extended till
The disposal.
till the appearance of the parties before the respondent number 3 or 27/5/2024, whichever is
My lord.
earlier.
All right.
all right
Yes, Mr. Chaudhary.
Item number 15, my lord. Can that matter be adjourned after 1 week, my lord?
15, other will be adjourned because second half, I'm assigned a different bench. Still, madam, will be taken. List of.